Court of Appeals, Division 1 is now in session.
Good morning. Thank you. You may be seated. We're here today in TRIYAR Capital versus REM Investment Company. It's our case number CV 150538. The argument is set for 40 minutes. Each side will have 20 minutes. Appellant will be responsible for reserving any time you might like for rebuttal. These proceedings are being audio and video recorded, so we would ask you to identify yourself and your client the first time you approach the podium. We have conferenced this matter. We hope we're familiar with the record and the briefing. I guess one point notice, initially Judge Peter Swan was scheduled to be on the panel, but he has recused himself, and Chief Judge Michael Brown has been substituted in place of Judge Swan. But we have conferenced this matter. We look forward to your argument. And with that, you may proceed.
May it please the Court, my name is Taylor Young of the Mandel Young firm, and I represent appellants Sam Sutton, Ann Sutton, James Vandala, and the defunct partnership REM Investment Co. I'd like to, at the outset, announce my intention to try and reserve 5 minutes for rebuttal, but I would also like to thank the Court for rescheduling the oral argument 2 weeks ago when I suffered an illness. I know that that's not convenient for anybody and wasn't convenient for me either, but I very much appreciate it on short notice. We're here on an appeal from a judgment in favor of TRIYAR, which is a large and established real estate development company who sued my clients over an option to purchase approximately 17 acres of land southwest of the intersection of Baseline and 24th Street. There are two main issues that the appellants are raising in this appeal. One is an issue purely of contract interpretation. What did the contract mean, the option contract mean, when it referred to approximately 17 acres of land? We believe that the
option agreement said approximately 17 acres of land and then listed two tax parcels.
Absolutely, Your Honor. In fact,
that's right.
It will be read, I'm sure, a number of times in the next 15 minutes. But that is true.
And is my understanding correct that regardless of whether the half acre that's in dispute is included in the agreement or not, it was still not exactly 17 acres?
There's no finding in the findings of fact and conclusions of law about the precise size of this.
But that wasn't my question.
Okay.
It's my understanding from the record that with or without the half acre, the two parcels were a little less than 17 acres.
With or without the half acre, it's not precisely 17 acres. I think the record shows that. So our main issue is contract interpretation. It's the issue of this clause. I think this clause really defines the case. The second issue is on our counterclaim for breach of the option agreement itself, related to these condemnation proceedings and the damages that we suffered as a result of that.
Okay. So I'm sorry. Were you done with the two?
I was just framing it, Your Honor. Please, Judge Kessler.
Okay. So we get to the first issue. I had a question. This legal description pops up. You have the option agreement that says two parcels, approximately 17 acres. No meets and bounds, the usually detailed meets and bounds description. And then at about the time it's assigned from Yori to TRIYAR, a legal description pops up that has meets and bounds,
Yes.
and also the two parcels. I think that's right.
When you say also the two parcels, I would say
says-
that it has a reference to, it says APN with the parcel numbers
Right,
after
but then
it.
it has meets and bounds. I'm just wondering, it's a little unclear. I know that, my understanding is that legal description popped out because it was apparently done by an underwriter for, was it First American? For the
Yeah, it was First
escrow
American.
company. But do we know, is there any, not going outside the record, just saying in the record, do we know anywhere, any other information from the record about who wrote that? How that legal description suddenly was written? I mean,
Well, I mean, I think the record is clear about what why the legal description was, what might have been a triggering event of the legal description. There's, my clients did a transfer of the half acre and then notified the title company, notified the escrow company that this transfer, that there had been a new deed recorded, and in response, when the legal description is done, it has the exclusion of the half acre. I think the record shows that.
the sale wasn't done through escrow, right? It was just,
The ultimate sale was done through escrow.
Oh,
there
yes.
was a
Half acre sale.
the half acre sale.
no, the half acre
exchange
no,
was
the half
not done
acre
in
sale was
escrow.
not done through escrow, and the plaintiffs in this case, make much of that. I think it begs the question.
Well, the judge said there was a breach of contract, partially
No.
because it wasn't sold through escrow.
And we think that it can only be a breach of contract if, in fact, it was part of the option agreement
Sure,
itself.
I understand that, but
Yeah.
so getting back to my question.
I mean, this is a very narrow and tight, I mean,
Okay.
a very sort of narrow legal analysis in terms of trying to understand exactly what's going on here. We have parties who never negotiated with each other. We've got the documents, and we've got to look at the language.
What's your best evidence that shows that TRIYAR would have been aware that the half acre was not going to be part of the option agreement?
Well, the TRIYAR would have been aware that the contract itself said approximately 17 acres and had a location. The location referenced these tax
It had the
parcels.
parcel numbers.
It had parcel numbers, but those parcels, it's clear that it couldn't have been the entirety of those parcel numbers because, as the contract itself notes, the option contract itself notes, there was a condemnation action going on
Forget the
right then.
condemnation action. Forget the
No,
condemnation
but
action
I-
from that. Why wouldn't,
Yeah, wouldn't those parcel numbers match the assessor's map? I mean, and a person could reasonably just take a look and say, yeah, this is about, here's where this property is.
I'm not.
And it's just-
I'm not disputing that, Judge Brown. What I'm saying is that if the question is, what does this approximately 17 acres refer to? If you are going to say the boundaries of these two parcel numbers are the 17 acres, that because we know there's a condemnation action, it can't be the entirety of those two
Condemnation
parcels.
action is specifically referenced, and the parties have agreed that the condemnation proceeds are going to go to, are not going to be
And I'm not arguing
given
the
to
proceeds
TRIYAR.
point.
So
Right,
I'm
right.
still not following why someone would not assume that it's the entirety of the two tax parcels minus whatever portion is subject to the condemnation proceedings.
I apologize. May I grab my water? I'm having
Sure.
a Marco Rubio moment.
Good.
The assumption that the parcels themselves, parcels are just a location of where these approximately 17 acres are in terms of the subject property, right? The actual definition of the term is location.
But they're tax partial numbers, right? I mean,
No, they're tax parcel numbers, right? And there's also a reference to Phoenix, Arizona, and
I understand.
288 feet. It's a
But
location reference, and I think that's important in terms of contract interpretation. If you look at the language itself, it says approximately 17 acres of land. Let me read it. directly.
You're reading the option agreement.
I'm reading the option agreement. I'm not talking about the assignment agreement. I assume the court is aware of the legal description, the fact that the assignment agreement says this more particularly describes the subject property.
Okay, so it's
Okay.
approximately 17 acres of land located 288 feet west of the southwest corner of 24th Street and Baseline Road in Phoenix, Arizona. Parcels 301-30-002 and 301-30-038.
That's telling the parties where the buyer where the property is located, but it doesn't have any specific reference to.
I mean, I read
But
that.
is the question, am I understanding you right, Mr. Young, that you're essentially contending that would not put a reasonable person on notice of what the option agreement was intended to do?
Well,
If it's so vague, it doesn't cover a legal description, then
It doesn't- it doesn't-
what good is it?
Well, it doesn't cover a legal description, but it specifically contemplates that the seller is going to warrant title pursuit, except to matters of
Let me ask you
on the public
differently.
record. Yeah.
Why wouldn't the two parcel numbers on a map provide or allow the option agreement to cover those two tax parcel numbers?
And the question is not whether it covers those two tax parcels, it's whether it covers those two tax parcels in their entirety.
Less the condemnation property.
Less the condemnation.
Everybody knew about it.
It's referenced in the document. My point is that the language itself doesn't contemplate the entirety of, all of. It can't contemplate all of.
Why not?
Because it doesn't say that. And if it said all of, it wouldn't include the condemnation
It would
portion.
make more sense to say parcel number 30, whatever the number is, minus a half acre. I guess I'm not following why, looking at those two things, someone looking at the option agreement wouldn't say it includes the entirety of these parcels, other than what we all know has been discussed regarding the condemnation proceedings.
I apologize. Let me back up. I think the issue here is that we have an agreement that had a history. It references these previous agreements, right? And there's an assumption that the parties are familiar with this property. The language itself says the subject property is these two languages. Could it have been written differently? Yes, but I don't think it's unclear in terms of approximately 17 acres. And approximately 17 acres were transferred.
Right,
and the legal description made it very clear what was.
But yes, I understand the legal description makes clear once you get the meets and bounds. But I guess the problem I'm having is we already agreed that approximately 17 acres is with or without half acre. And we know the condemnation, the agreement recognizes, the option agreement recognizes can be a condemnation of a certain portion of the land. So we know that's going to be gone. But I'm looking at it and it says it's approximately 17 acres, and then it says these two parcel numbers.
Yeah, it says where those acres are located.
Right, and I understand that's what you're saying, but the question is, as I understood your argument is, the best way to determine what was being sold was by the agreement itself. And the agreement didn't say all of the parcel numbers.
Correct.
The entire parcel numbers, and therefore that should have alerted someone to say, oh, gee, I'm not getting, putting aside the condemnation, which have been there, I'm not getting all of the parcels.
Yeah, that's what I'm saying.
Okay.
And again, this is and as a matter of contract interpretation, we have these findings of fact and conclusions of law, and the findings of fact and conclusions of law. We can talk about the standard of review, but it's our contention that this is a de novo standard of review. This court can interpret this language and should interpret this language, and doesn't need to follow a clearly erroneous standard.
Even though previously in the condemnation action we made an appeal when we vacated that judgment, and my understanding that judgment gave TRIYAR title to the half acre. We vacated that, and we said there was an issue of fact on what was actually being transferred.
There was an issue of fact. It wasn't ripe for determination at that time, but what we have, but the findings of fact and conclusions law in this that you're dealing with in this case don't say anything other than it expressly states this. There's no other factual support.
Suggesting there's a history that leads up to this, but what is there in the option agreement that would put someone on notice of some previous history or something that someone would be aware that would lead someone to believe that there's a separate agreement that a half acre is going to be sold, and so the entirety of the two parcels is not really subject to the option agreement?
Well, the option agreement references the history of the previous agreements, and
The Cohen agreement?
it's in the Cohen agreement.
Cohen agreement also lists the two parcels?
The Cohen agreement did list the two parcels, and the Cohen agreement also referred to
Approximately
17.5 acres
Right.
versus
But-
17 acres. So
But
that's a,
this agreement also says, if I remember right, I could look at it, but you can refresh my recollection. The option agreement says, this is the final agreement. Anything else is.
it has that kind of integration language in it. But the question was, what would alert somebody? There's a recitation here that says we've had a history. There's a recitation that the parties are familiar. Now, in this instance, what we have is TRIYAR is the plaintiff in this case. TRIYAR got assigned this option agreement.
With the
had
legal
no
description.
What now? With the legal description.
But that's why I asked, where'd the legal description come from? Because suddenly this pops up and there's testimony, as I understand it, that I didn't understand what this meant.
Oh,
And
yeah,
when-
there's definitely testimony, and it was interesting, as we note in our briefs, Judge Brain didn't seem to have a problem understanding. He said, oh, it's about a football field that's being excluded here. He said that off the cuff during the trial. So it was evident to him, but apparently not evident to TRIYAR's
Well, they have-
certified real estate specialist attorney or experienced
Or the
principal.
escrow agent, as I understood.
Or the
Even
escrow
The escrow
agent.
agent said, I didn't understand what this
She
was.
testified afterwards that it was her, both she and counsel for TRIYAR testified about their beliefs as to what the contract covered.
Right.
I see that I'm already down under my 5 minutes. I'd like to reserve the rest of my time for rebuttal, if I might, unless the court has further questions on.
Sure.
Thank you.
May it please the court, I'm Joseph Glenn. I represent TRIYAR Capital, LLC, and I'll be addressing the REM, Sutton, and Vandola appeal, and I'd like to reserve about 10 minutes for my partner to address the Aspen appeal separately. The first thing,
Technically, he never addressed the Aspen appeal, so there's nothing to rebut to.
well, Aspen hasn't appeared. There's nobody
Well, they ceded
that's
the
appeared on
time. They
behalf.
ceded the time, whatever time of the 20 minutes they had,
Sure.
so, but okay, go ahead.
Just a couple of things to point out. I think the option agreement, we've talked about the description, but in the option agreement it says seller is when we're looking at the definition of the subject property, seller is the owner of approximately 17 acres of land located 288 feet west of the southwest corner of 24th Street and Baseline Road in Phoenix, Arizona, and then it identifies the parcels numbers, subject property. It doesn't say that's what the seller owns, is those entire parcels. And then when you go down to paragraph 1, when it talks about the conveyance of the property, it says the subject property. So I don't know how anybody could look at this agreement and say, okay, seller owns all this property and it's going to sell all this property, but somehow is reserving a right to convey to himself some portion of that property.
At the date of the agreement, the option agreement, REM owned both parcels.
The entirety of both parcels.
Yes, that's what I meant. That's what I'm getting at.
Yes.
It owned, okay.
And it specifically identifies and says, that is the property we own, that is the property we are selling.
And it wasn't until after the agreement, option agreement was entered into, that REM transferred the half acre to, outside of escrow to Sutton.
Exactly, and I think the timing here is important. The option agreement is entered into in 2016. It's a year option. Throughout this entire year, there are site plans that are approved by Mr. Sutton that shows the entire parcel of both parcels being developed. There's no mention of any conveyance anywhere else, no surveys done to show that he's going to carve off some property. Over 11 months go by, and then right before close of escrow is when this conveyance happens.
April 26, 2007.
Yes. And at that time, right before close of escrow, there's no legal description out there. I mean, the option agreement is the operative document, and so when the legal description gets attached to the assignment happens as part of close of escrow. This isn't something that happens halfway through the process. The assignment happens as part of close of escrow. The warranty deed that has the legal description attached, that's all close of escrow. So people show up, the last couple of days before close of escrow, and you've got a legal description. Everybody just signs on the dotted line, and then they don't realize until a couple of months later that what had happened.
Isn't there a risk doing that as a buyer? I mean, let's go back to the option agreement.
Sure.
It says buyer is thoroughly familiar with the subject property, having previously participated in several prior negotiations. If you're thoroughly familiar with the subject property, isn't it incumbent upon you to take a good hard look at that legal description before you buy the property and say, I'm thoroughly familiar with this property, I need to make sure this is the same property?
Well, I have two comments to that. One is that when the property is referenced in the option agreement, it's identified by two specific assessor's parcel numbers. There are exact legal descriptions that go along with that.
But the buyer could have insisted that escrow close on those two parcel numbers, I suppose, although the title company probably would have balked at that. But
sure.
Go ahead. Yeah.
My other point is that this is a breach of contract case. The operative document is the option agreement. There's no fault determination here. Either they conveyed what they were supposed to convey or they didn't. It was not incumbent upon TRIYAR to figure out and catch that Mr. Sutton was doing something dishonest. There's no obligation. There's no weighing of fault here. So, yeah,
it seems
maybe
like you're suggesting, though, that any time there's a problem with a legal description, which happens sometimes, that you're suggesting that the seller would be at fault every time.
No, it would depend on. It depends on what.
I shouldn't use that fault, but a breach requires, what portion of the agreement did they breach?
And it's the option agreement. I mean, that's the agreement between the parties. That's the operative document. I think, the Superior Court, one important point I would make is finding of fact number 23 was written entirely by the Superior Court. There were four things that they changed in the proposed findings of fact and conclusions of law. They weren't adopted verbatim. The court changed and added and made at least four changes that I noted. But if you look at findings of fact number 23, this was written entirely by the Superior Court and added. And it says, Defendant Sutton relies heavily on the fact that the option documents did not have a legal description and that the parties later signed supplemental escrow instructions containing a legal description that did not include the isolated half acre. As noted above, the operative contract was the option agreement, and the court finds that the parties' intent was for the option to include the entire parcel. And I think the Hill-Schaefer case is a great case that shows exactly what can happen. In that case, there was almost a very similar situation where the legal description was incorrect. The parties had a listing, they had an agreement as to what was going to happen, and then at close of escrow, the wrong legal description popped up. And important to note, the court says, the court rejects the idea that a legal description, here the Supreme Court says, the legal description contained in the contract, the Court of Appeals reasoned, contained no ambiguity or ambivalence. In fact, a legal description is the most precise description that can be devised. Therefore, the Court of Appeals held that a seller cannot claim a misunderstanding occurred or that no meeting of the minds existed as to the essential term. Although the Court of Appeals logic has a certain force to it, we cannot agree with it. And then it talks about how other factors and other documents can be considered to determine what was the party's intent. But I think another thing that's really interesting is that the court said this: seller believed that the description contained in the offer described the property that had been listed and discussed. Had buyer accepted the offer on that basis and with the same intent, a binding contract subject to reformation might well have been formed for the sale of the land north of Butler. So the Supreme Court here says the parties can have a meeting of the minds and on something other than what is described in the ultimate legal description. And the court says, and in that case, there would have been reformation and the parties would have had a meeting of the minds, notwithstanding the fact that the legal description was incorrect. And that's, what we have here. And the court found, there was no misunderstanding. This was not a mistake or a misunderstanding. All the evidence that was submitted, the site plan approval that occurred during the option period showed that the parties intended to convey.
Where's the site? Could you have a record site to the evidence about the site plan?
I do. Just 1 second.
And that included the half acre?
It included the half acre.
Okay. 'Cause I didn't catch that.
That would have been submitted to the city?
It would have been submitted to the city, and because during the option period, it's still in REM's name, REM has to sign off on that site plan approval. So let's.
Is there a reference in your brief to
There is. In our statement of facts, we refer to that.
And did the site plan include construction on that part on the half acre or some sort of access through that part of the property?
I don't know exactly what construction-wise was on that. I just know that it included the entirety of both parcels. And another thing is, if somebody was going to, if the intent of the parties was that somebody was going to carve off a piece or that we're going to convey you 17 acres, we're just not going to tell you what 17 acres it's going to be, you're going to have, in escrow, you're going to have a parcel split, you're going to have a survey that's going to have to be submitted, you're going to have to submit that submission to the assessor so that they can assign a parcel number.
The judge basically found there were two types of breach, right? One was you didn't sell them the entire 2 parcels, and the other is you sold it outside of escrow.
Yeah, and that is all evidence that he knew what the agreement was, and he was trying to do something else and trying to hide this.
I asked your opposing counsel, and I don't know if it intrigued me about how this legal description suddenly popped up, and the best I could figure out, and my law clerk could figure out, was that it suddenly popped up from the underwriter for First American Title. But is there any evidence in the record of where the underwriter got the legal description from?
I don't. Just my knowledge of how the process works. I'm sure the underwriter would have seen, would have pulled the title history from the 2 parcels, would have seen that had been transferred out.
Because there's evidence that my understanding is there's evidence that the conveyance of the half acre may not have gotten recorded, or was not recorded until after close of escrow.
No, it was recorded. I believe it was recorded, and I mean that's how the underwriter would have gotten it, because the escrow agent testified that she didn't know what had happened. So it would have had to have been the underwriter would have said, okay, here's the title history of these 2 parcels.
It was listed in the Schedule B. It was listed in the title exceptions?
No, I don't believe it was.
Right. What the title exception says something of record, things of record. But I thought there was evidence from someone from the assessor's office saying that may not have, could have taken months to have that recorded.
Yeah, and that's the difference is the deed itself had been recorded, but no assessor parcel number had been assigned, nothing had been submitted to the assessor, so that was non-existent. So nobody could have gone and looked at the assessor parcel maps and seen that this had happened. And, Mr. Sutton testified that he just made up a parcel number because he was leaving out of town.
So if I were TRIYAR's attorney and wanted to say, okay, what's of record, I'd go to those parcel numbers, and there's nothing of record in the chain of title. that's something being carved out of those parcel numbers?
Yeah, if you were to take those parcel numbers, look on the assessor's website, GIS maps, and you would pull up those parcels, there would not have been any kind of a carve out because nothing had been submitted to the assessor for the assessor to parcel off another parcel and assign it a parcel number. And that was the testimony of Mr. Drummond, was that, the assessor parcel numbers that he looked at, if he had gone and looked at the map, it wouldn't have shown it. And unless the court has any other questions on the REM portion of the appeal, I'll reserve the remainder of my time to my partner to address the Aspen appeal. Thank you.
Good morning. May it please the court. My name is Richard Cobb, and I'm here to address the Aspen portion of the appeal. There are, in addition to whatever questions may be in your minds, there are three issues that are raised in the reply brief that I think merit being fleshed out a little bit further. And I'm happy to answer any other questions that you may have, but the three issues that merit being fleshed out are: first, does Hill versus City of Phoenix, this issue about giving notice of the intent to appeal the losing motion for summary judgment, does Hill versus City of Phoenix mean that 12-2102 applies? The second issue is whether or not, when there's a loss on a motion for summary judgment, it's appealable at all, whether this was a pure legal issue. And the third is whether or not, when there's a statute of limitations question like this, if two competing title owners who each have this property in their chain of title are arguing with one another, whether there's ever a statute of limitations.
Well, let me cut to the chase.
Please do.
These are my concern on the statute of limitations. It seems to me that it doesn't matter whether, and tell me where I'm wrong on this, it doesn't seem to me whether it's a quiet title action or a declaratory judgment action. You look at the nature of the proceeding, the underlying cause of action, to see if there's a statute of limitations and what it is. But assuming that there is a 3-year statute of limitations, which is what, as I understand
4.
the argument, 3 or 4.
4.
But during that period of time, as I understand it, and it starts, I guess, in August 2008 is the argument.
In their briefing, it says August 2009, and their motion for summary judgment on it said 2009.
Right, but I think it may have been 2008. But regardless, during that period of time, TRIYAR had title for
Yes,
a good
it did.
portion of that time, because
Yes, it
in the
did.
condemnation court, the judge had said, I am awarding TRIYAR title, I am basically quieting title, and they get it. During that period of time, there's no statute of limitations running, in my view. I mean, may be wrong, but there's no statute of limitations running because TRIYAR has been awarded a judgment in the condemnation action saying you own the property.
Then perhaps I'll be seated. Then perhaps I'll be seated.
Well, I don't, they may have more questions, but
No, that's exactly right. There's never been a case in the history of Arizona that I am aware of whereby the court has intervened in the middle of a purported statute of limitations, quieted title in one person's name, and then for a period from January of 2011 through April of 2012, TRIYAR's entitled. And so during the purported 4-year period, for 15 months, we're entitled. And the notion that the statute of limitations has run out on us is kind of hard to understand for exactly that reason.
right, I mean, because even if it's a 3-year statute, if you got 15 months of the 3 years,
We still have it.
I mean, why would you bring a quiet title action if the condemnation court's already given you title? Right?
Exactly
Is
our
that the
point. And in addition to that, whenever two parties each have a piece of 301-30-003A in their title, you've got two competing parties who theoretically have the disputed land in their title. How can there ever be a statute of limitations whereby they would clear title against one another?
Wait. Let me back up and apologize because I don't understand all the facts yet.
Really?
But the quiet title action, I thought, was just filed against Aspen.
It
And
was.
Aspen's not a title owner. They're just a holder of the lien.
The quiet title action is filed as against the Suttons because they
Not Aspen.
deeded the half acre to themselves. The Suttons did.
Okay, I thought, and the quiet title was not against Aspen?
It was against Aspen and the Suttons. I'm sorry.
Okay, it was against both.
Yes, it was.
So it's a quiet title against a lien holder and a disputed title.
That's exactly
Would there be different analyses for those two groups? I mean, basically, say you're trying to quiet title to a property that just has it's just involving a lien. I don't pay my mortgage, but for whatever reason, I'm lucky, and they never foreclose. And years go by, and I want to file quiet title to get that lien wiped off. Is there a statute of limitations issue?
In Arizona, it's very well established that a plaintiff in possession doesn't have a statute of limitations to clear title as to some cloud on title on his property. But the state of Arizona doesn't have a decision that governs an issue quite like we faced in this case.
With competing
That's right.
claims of ownership.
That's right. The state of Utah has a case, I'm going to mispronounce the name, but it's the Hupaina Trust, where somebody owned a piece of land and it got conveyed twice. And so one of the parties that received title sued the other one in a quiet title reformation, much like we did. And the court addressed this issue of the statute of limitations and said, look, when two different competing title owners both have the land in their warranty deeds or special warranty deeds, there can't be a statute of limitations. Otherwise, they could never clear title against one another. And that's what we faced when we sued REM and the Suttons. And to my point, how could we ever have a statute of limitations when there's two competing title owners?
But the Suttons didn't move for summary judgment.
No,
For
Aspen
REM.
did.
Aspen moved for summary judgment of the statute of limitations.
That's exactly right. And one of the other points that we would like to address, just briefly, the general rule of thumb is you can't file a motion for summary judgment on a losing issue. Whether or not this motion for summary judgment is a pure issue of law is decided in the John C. Lincoln case that says that it has to be a pure legal issue. In footnote 5, it says where the facts are immaterial, not undisputed, but immaterial. And their own moving papers, Aspen's motion for summary judgment statement of facts and the motion says that the statute started to run in 2009. Now in the briefing for the first time on appeal, they say it starts to run in 2008. And I only bring it to your attention because it illustrates the importance of when it starts. There's an issue of fact sitting out there that's as big as the all outdoors. But setting that issue aside, the argument fails again because nothing precluded them from introducing evidence at trial about the statute of limitations. It was their own decision not to show up.
But putting all that aside, I just want to make sure I understand. I've been told that I have a firm grasp on the obvious. Regardless of all of that, assuming we had jurisdiction, and assuming there's a disputed issue of fact as to when the statute of limitations began to run, because the dates are different, regardless, the point isn't the decisive factor that during that 12 or 14 or 15 month period of time when TRIYAR had total title because of the judgment and the condemnation action, the statute didn't run during that period of time?
Had my client sued Aspen during that time period, we'd have been thrown out and probably sued for wrongful institution of civil proceedings.
Right. But so the statute couldn't have run because of that period of time?
Could not have.
Okay.
Thank you.
So I'd like to get back to a question that Judge Brown asked, which I thought was a good one, which is, shouldn't TRIYAR have been on notice and wary and checked out the legal description? And I want to just draw the court's attention to the evidence in the record that they were aware that the legal description had changed and made the decision to go forward anyways. They didn't stop to try and clarify what was going on.
They did check with the surveyor, right? They did check with the surveyor who did a survey, I think, in 2005.
They did have they made reference to the surveyor, but I don't believe the testimony says that gave them comfort that what they were purchasing didn't exclude what it said it excluded.
Again, this was all on the verge of the eve, so to speak, of the closing, the date they had to close escrow, because the period was about to end. And as I understand it, the judge makes a finding that says it was an excusable mistake for TRIYAR to sign off on an erroneous description. So how do you get around the finding of fact that it's an excusable, even if you wanted to go that route? I understand your argument.
No,
but if you do, the judge makes a finding is excusable neglect.
Sure, and we would say
not
that
neglect,
that
excusable.
it's a conclusion that it's excusable, and the question is what are the facts that underlie that in the findings of fact. There is nary a fact in the actual findings of fact that support the conclusion that's waived. It's just a simple conclusion that there was no waiver here because they were confused and didn't understand.
But
There are facts. I mean, the fact that the option agreement just lists the subject property as being the two parcels.
And if we're at that point, again, I think that's circular back to the contract interpretation issue. If in fact the subject property meant all of those parcels, even excluding the whatever portion was going to end up being condemned, then you don't need the legal description discussion at all because we have because as they've established, the option agreement is the operative agreement, and that's what they sued for breach of. So that's a contract interpretation issue. I would reiterate that the contract, however, doesn't provide any metes and bounds in it. It doesn't have a legal description in it. It refers to an approximate amount. It has a warranties clause that says we're warranting except to what's in the record, and I followed that discussion, Judge Kessler, but it puts them or diligent investigation. It certainly put TRIYAR, who is legally speaking, a stranger to this transaction. They're getting an assignment right at the very last minute.
And that's when the legal description pops up.
The legal description popped up earlier to that, but that's
not
when
much,
they
not much earlier.
not much. I don't disagree with you.
And
That's
then
all.
the judge makes findings of facts earlier, saying due to the technical nature of the legal description,
Correct.
neither Yari or TRIYAR's attorney knew or understood the legal description excluded the half acre. Sizemore did not understand the legal description excluded the half acre. Then goes on, says, before the transaction closed, Drummond submitted an ALTA survey of the subject property to First American. Both Drummond and Yari understood and believed that TRIYAR was purchasing the property depicted in the survey, which included the half acre. So all those are
Sure.
findings of fact.
No, I agree that there's a finding of fact of belief, and I also agree that there is a finding of fact. I say it's clearly erroneous. It's not supported by the evidence to have the experienced and a certified specialist in real estate say, I don't know what this legal description means. With that, I see I'm out of time.
We are out of time, but I would be interested in maybe your 30-second response to the statute of limitations argument in terms of why would a statute of limitations begin to run at all against TRIYAR when the documents that they have show that they don't reference.
Judge Cannon, I would love to do that. I don't represent Aspen in this case, so
So Aspen hasn't shown up.
they're
They ceded their time to you.
they ceded their time to me. They did not cede their argument to me.
Fair enough.
No problem.
I apologize, Judge Conley. I wish I could answer your question.
Thank you. Thank you for your argument. We will take this matter under advisement and issue a decision in due course. And with that, we will adjourn for a recess before our next argument.